Many foreign investors entering Vietnam are attracted by the market potential and growth opportunities. However, when facing foreign ownership restrictions in Vietnam, some choose to use a nominee structure as a workaround. On paper, the investment appears compliant. But in reality, if you do not legally own your shares under Vietnam law, your control may not exist when it matters most. A nominee structure in Vietnam typically involves a local individual or entity holding shares on behalf of a foreign investor. The foreign investor provides the capital and expects to retain control through private agreements. However, under Vietnam business law, the registered shareholder is the legal owner. This creates a fundamental gap between beneficial ownership and legal ownership. Foreign investors may use nominee arrangements in Vietnam to enter restricted sectors, simplify licensing procedures, or accelerate market entry. While these reasons are commercially understandable, they introduce legal risks for foreign investors in Vietnam. What appears to be a practical solution can become a structural weakness in your investment. The key issue with a nominee structure in Vietnam is that it operates in a legal gray area. Vietnamese law does not provide a clear mechanism to fully protect beneficial ownership in nominee arrangements. If a dispute arises, courts and authorities will generally recognize the registered shareholder as the legal owner. This means your rights may not be enforceable in practice. Many foreign investors rely on side agreements such as nominee agreements, powers of attorney, or loan arrangements to secure their position. While these documents can provide some level of control, they do not eliminate legal risk. In certain situations, these agreements may be challenged or deemed unenforceable, especially if they contradict mandatory provisions of Vietnam law. There have been real cases where foreign investors lost control of their companies in Vietnam due to nominee structures. In some situations, the nominee refused to transfer shares back. In others, internal agreements could not be enforced in court. These outcomes highlight one of the most serious legal risks when investing in Vietnam through informal structures. Even if the nominee is trusted, the structure itself remains fragile. Changes in relationships, financial pressure, or external disputes can quickly alter the situation. Without legal ownership recognized under Vietnam company law, control depends on cooperation rather than enforceable rights. His is not a position most investors intend to be in. While nominee structures cannot be made completely risk-free, certain legal strategies can reduce exposure. These may include carefully drafted agreements, layered control mechanisms, and alternative investment structures such as joint ventures or business cooperation contracts in Vietnam. Each case requires a tailored approach based on the investor's objectives and the regulatory environment. At LTS Law, we provide legal services for foreign investors in Vietnam by assessing investment structures and identifying potential risks. We advise on whether a nominee structure is appropriate and, if used, how to mitigate its risks through proper legal documentation and strategic structuring. Our goal is to balance compliance, practicality, and protection. A nominee structure in Vietnam may appear simple at the beginning, but its legal implications can be significant. Before proceeding, it is essential to understand how Vietnam law treats ownership and control. Visit lts.com.vn and consult with our legal team to ensure your investment in Vietnam is structured in a way that protects your interests from the start.